Let's think. You're enjoying a Saturday afternoon at a local street festival in downtown Orlando. You've got your sidearm concealed, feeling confident because you've heard the news. Florida is now a permitless carry state. You think the days of government paperwork and fees are behind you. Suddenly, a minor altercation breaks out nearby. The police arrive, they question everyone, and they notice the print of a firearm under your shirt. You smile, tell them you're legal under the new laws and expect to be on your way. Instead, you're in handcuffs. You're being loaded into the back of a cruiser, and the officer is telling you that you're facing a third-degree felony. How did constitutional carry lead to a jail cell? Since Florida's permitless carry law went into effect in July 2024, there's been a dangerous misconception spreading across the state. People think permitless carry means no rules. They think it means total freedom. And that misconception is landing good people, law-abiding citizens, in handcuffs. We're seeing a massive surge in what I call the permitless trap. People think Florida has become the Wild West. They think permitless means lawless. It doesn't. The truth is, Florida's new law didn't eliminate the rules. It just changed who needs a permit and when. But if you don't understand the fine print, you're walking into a legal minefield. In fact, for many of you, the changes have actually made the legal landscape more dangerous because the margin for error has disappeared. Today, we're breaking down exactly what you still can't do without a permit and why the freedom everyone's celebrating might actually be a one-way ticket to a felony record if you aren't careful. Most people think that as long as they aren't a convicted felon, they're good to go. But did you know there are over 7 different hidden disqualifiers that can turn your lawful carry into a crime instantly? Let's look at the actual text of Florida Statute 790-1. The law says you can carry concealed without a license only if you meet the same criteria required to get a license under Florida Statute 790-6. This is where the trap is set. Under the old system, if you applied for a permit and didn't qualify, the state just sent you a rejection letter. No big deal. You stayed home. But under the new system, there is no rejection letter. The test happens in real time, on the street, with a police officer. If you don't meet those requirements and you're carrying, you aren't just unlicensed, you are committing a crime. So what are these qualifications? Number 1, you must be at least 21 years old. No exceptions. If you're 18, 19, or 20 years old, permitless carry does not apply to you. The only exception? Active duty military or honorably discharged veterans. If you don't fall into that narrow slice of the population, 21 is the hard line. If you're 19 and carrying because you heard it's legal now, you are in serious trouble. Number 2, no felony convictions. Ever. Even if your rights were restored, even if it was decades ago, federal law still prohibits you from possessing a firearm. And Florida's permitless carry law doesn't override federal law. Number 3, no recent misdemeanor convictions involving violence. That includes domestic battery, aggravated assault, even some stalking charges. If you've been convicted of one of these offenses in the last 3 years, you're disqualified. Number 4, and this is where it gets tricky, no history of substance abuse. Now this one's vague, and that's intentional. If you've been to court-ordered rehab, if you've had multiple DUIs, if there's any documented pattern of drug or alcohol abuse, the state can argue you're not eligible. Let me give you a real example from a case we handled recently. I'll call him Mark. Mark had a clean record, no felonies. He was 24 years old. He was carrying a concealed firearm in a backpack while walking home. He got stopped for a broken taillight on his bicycle. The officers found the gun. Mark thought he was fine. What Mark didn't realize was that 2 years ago, he had been court-ordered into a 30-day outpatient treatment program for alcohol abuse after a messy breakup. Under Florida Statute 790.06, if you have been committed for the abuse of a controlled substance or alcohol within a certain time frame, or if you have a history of chronic or habitual use, you are ineligible. Because Mark didn't have a permit, which would have caught this issue during the application process, he didn't know he was prohibited. He walked right into a felony charge because he assumed his clean record was enough. Number 5, you can't be subject to an active domestic violence injunction. Even if you haven't been convicted of anything, if there's a restraining order against you, you cannot legally possess a firearm. And number 6, you must be mentally competent. That means no involuntary commitments under the Baker Act, no adjudications of mental incompetence. If any of these apply to you, permitless carry doesn't help you. You're still committing a crime. Now here's where it gets dangerous. How does law enforcement know if you're disqualified? They don't, not right away. And that's creating a gray area that's dangerous for everyone involved. Under the old system, if you were carrying concealed, an officer could ask to see your permit. If you didn't have one, you were arrested. Simple. But now, if you're stopped and an officer discovers you're carrying, they can't automatically arrest you just for not having a permit. They have to determine whether you're eligible under the statute, and that means running your background, checking for disqualifiers, making judgment calls. But here's the problem. Some officers don't know the new law. Some departments are still training their people on how to handle these stops. And in the meantime, people are getting arrested when they shouldn't be. Or worse, they're being let go when they're actually committing a crime. We've had clients who were arrested, spent the night in jail, had their gun confiscated, only to have the charges dropped a week later when the state realized they were legally eligible to carry. That's the reality right now. But let's say you are 100% eligible. You're over 21, you're sober, and your record is white glove clean. Does that mean you're safe? Not even close. There are 15 specific red zones in Florida where your permitless right vanishes the moment you cross the property line. And some of these places look like normal everyday buildings. Even if you're the perfect citizen, the law doesn't follow you everywhere. This is the biggest misconception I see. It's my right, so I can take it anywhere. Wrong. Florida Statute 790.06, Subdivision 12, lists out every place where firearms are prohibited. These are zones where your permitless right and even a licensed right completely vanishes. Let me say that again. Even if you qualify for permitless carry, you are still breaking the law if you bring a gun into a restricted location. So where can't you carry? Number 1, any police station, sheriff's office, or highway patrol station. Obvious, right? But people still try. We had a client last year who walked into a sheriff's substation to file a report about a stolen package. He forgot he had his gun on him. He was arrested before he even made it to the front desk. Number 2, any detention facility, prison, or jail. Again, seems obvious. But this also includes areas around these facilities. If you're visiting someone in jail, leave your gun at home or locked in your car. Number 3, courthouses and courthouse facilities. This doesn't just mean the courtroom. It means the entire building. Some courthouses have cafes, law libraries, even public parks on the property. If it's part of the courthouse complex, guns are not allowed. Number 4, polling places during elections. You cannot carry a firearm into any location where voting is taking place. That includes early voting sites. Even if you have a concealed carry permit, even if you're otherwise eligible, you cannot bring a gun into a polling place. Period. Number 5, any meeting of the governing body of a county, public school district, municipality, or special district. That means city council meetings, school board meetings, county commission hearings. These are public meetings, open to the public, but firearms are banned. Number 6, any school, college, or professional athletic event not related to firearms. So high school football games, college basketball games, even little league tournaments. If it's a school-sponsored event, guns are off limits. And this is where people get confused because they think, I'm not going into the school building, I'm just at the field. Doesn't matter. The law applies to the event, not just the building. Number 7, any career center. That's a specific type of vocational school. If you're not sure whether a location qualifies, assume it does. Number 8, and this is the one that trips everyone up. Any portion of an establishment licensed to dispense alcoholic beverages for consumption on the premises, if the primary source of revenue is the sale of alcohol. What does that actually look like in real life? If you're at a chain restaurant that serves alcohol, you can usually sit in the dining area with your concealed firearm. But the moment you walk over to the bar side to wait for a table or talk to a friend, you have entered a restricted zone. You don't even have to order a drink. Just standing in that primarily devoted space is enough for an arrest. I've seen cases where a guy was just using the bathroom located near the bar area and ended up in handcuffs. The law doesn't care about your intent. It cares about your coordinates. But here's the trick. How do you know if more than 50% of an establishment's income comes from alcohol sales? Most places don't advertise their revenue breakdown, and the law doesn't require them to post signs. So if you're not sure, don't carry. Number 9, any college or university facility. This is broader than just classrooms. It includes dormitories, administrative buildings, libraries, dining halls, even outdoor campus spaces in some cases. Now, there is an exception. If you're a registered student or faculty member and you have a concealed carry license, you can keep a gun locked in your car on campus. But that's it. You can't carry it on your person. And if you don't have a license, even that exception doesn't apply. Now, let me tell you about a case we handled just a few months ago. And this is a real-life example that shows exactly how these laws can trap people who think they're doing everything right. Our client, let's call him David, is a 35-year-old contractor, no criminal record, legally eligible to carry under the new permitless carry law. He's got his gun in a holster on his hip, concealed under his jacket. He's driving through Tampa on his way to a job site when his 10-year-old daughter calls. She forgot her science project at home, and she's got a presentation in an hour. David's a good dad. He turns the truck around, grabs the project, and heads to his daughter's school. Now he knows he can't take the gun inside the school. He's not an idiot. So he parks in the visitor lot, locks his gun in the glove box, and walks into the front office to drop off the project. He's in and out in 3 minutes. Problem solved, right? Wrong. As he's walking back to his truck, a school resource officer, that's a cop stationed at the school, stops him. Someone saw him put something in his glove box and reported it. The officer asks David if he has a weapon in the vehicle. David says yes, it's locked in the glove box. The officer asks to see his concealed carry permit. David says he doesn't have one, but he doesn't need one under the new law. The officer doesn't care. He arrests David on the spot. The charge? Possessing a firearm on school property under Florida Statute 790-115. Now David's thinking, I didn't bring the gun into the school. I left it in my car. That should be legal, right? Wrong again. Under that statute, it is illegal to possess a firearm on any school property, and that includes parking lots, athletic fields, and anywhere within 1,000 feet of the school campus. There is an exception. If you have a valid concealed carry license, you can keep a gun locked in your vehicle while on school grounds. But David doesn't have a license. He thought he didn't need one under permitless carry, and that's where he was wrong. You see, permitless carry allows you to carry in most public places, but it doesn't override the specific restrictions for schools. If you're going to be on school property, even just in the parking lot, you need an actual concealed carry license to have that gun in your car. Without it, you're committing a felony. David spent the night in jail. His truck was impounded. His gun was confiscated. And he was facing up to 5 years in prison. We fought that case hard. Eventually, we got the charge reduced to a misdemeanor with probation. But it cost him $15,000 in legal fees, and he's got a criminal record now, all because he thought permitless carry meant he could carry anywhere. That's the reality we're dealing with. The law isn't clear, the exceptions aren't intuitive, and the consequences are severe. Now let's talk about what happens when you're behind the wheel. This is where the updates get incredibly messy. You've probably heard the phrase, your car is an extension of your home. In Florida, that's a dangerous half-truth. We've talked about where you can walk, but what about when you're driving? You spend half your life in your car in Florida. You think you can just toss your gun on the passenger seat? That is the fastest way to get a felony. Under Florida Statute 790.35, you have the right to possess a firearm in your private vehicle. But there is a massive legal distinction between possessing and carrying. If you do not have a permit, the law generally requires the firearm to be securely encased. That means it needs to be in the glove box, a snapped holster, a zipped bag, or a closed console. It cannot be sitting on the passenger seat under a towel. It cannot be wedged between the seat and the center console. If a police officer can reach in and grab it in one single motion, you are readily accessible, and that is a criminal offense. Florida courts have interpreted securely encased to include a glove compartment, a center console, a zippered gun case, a holster with a snap closure, basically any container or storage area that requires an extra step to access the firearm. But here's the critical part. The gun has to be in the vehicle's storage space, not on your body. This was the exact issue in State v. Valley, a case from the 2nd District Court of Appeal in 2024. In Valley, the defendant was pulled over for a traffic violation. During the stop, the officer noticed a bulge under the defendant's jacket. It turned out to be a firearm in a zippered pouch strapped across his chest. The defendant argued that the gun was securely encased because it was in a zipped pouch. The court disagreed. They ruled that because the gun was on his body, not in a storage compartment of the vehicle, it didn't meet the definition of securely encased. But here's the twist. Since permitless carry began, many people think they can drive with the gun holstered on their hip without a permit. Technically, if you are otherwise eligible, you can carry it concealed on your person while driving. But here's the problem. What happens when you get out? If you pull into a post office parking lot or a school drop-off line with that gun on your hip, you have just transitioned from a legal state to a felony state. If you don't have that physical permit, you lose the school zone protections afforded by federal law, the Gun-Free School Zones Act, which often hinges on having a state-issued license. Without the license, even the parking lot of a school can be a legal landmine. I want to tell you about Sarah. Sarah is a single mom, no criminal record, totally eligible for permitless carry. She kept her handgun in a magnetic mount under her steering wheel for easy access because she worked late shifts. She didn't have a permit because, as she told me, the law says I don't need one anymore. Sarah was in a minor fender bender in a supermarket parking lot. When she reached for her insurance in the glove box, the responding officer saw the gun mounted under the dash. Because the gun was not securely encased, it wasn't in a closed container, and Sarah didn't have a permit to carry it on her person in a way that the law clearly defined as concealed carry at that time. She was charged with unlawful carrying of a concealed firearm. The magnetic mount didn't count as a case. She spent the night in jail and thousands on a legal defense for a mistake that a $15 holster and a permit would have prevented. And we can't ignore the newest headache, open carry. A lot of folks assume that if Florida allows permitless concealed carry, then open carry must be legal too. That makes sense, right? If the state trusts you to carry a hidden gun, surely they trust you to carry a visible one. But that's not how the law works. Under Florida Statute 790.053, open carry is still illegal in almost all circumstances. The only exceptions are when you're engaged in fishing, camping, hunting, or lawful target shooting. As of late 2025, following the McDaniels ruling, open carry has been decriminalized in many parts of Florida. But I'm telling you right now, do not be the test case. The Attorney General has issued guidance, but the statutes haven't been fully rewritten by the legislature yet. We are in a gray year. Many local law enforcement agencies are still operating under the old mindset, and the menacing or improper exhibition statutes are still very much in play. If you walk into a grocery store with a sidearm on your hip, you might not be breaking the open carry law anymore, but you are inviting a disorderly conduct or improper exhibition charge if someone feels threatened. Let me tell you about Dave. Dave knew about the fishing exception. He was headed to the pier. He had his rod, his tackle box, and he was openly carrying his handgun on his hip, which is technically legal under the statute while engaged in or traveling to or from fishing. But Dave decided to stop at a gas station 3 miles away from the water to buy ice and a sandwich. A nervous clerk called the police. Dave told the officers, "I'm going fishing. It's legal." The officers didn't care. They arrested him for improper exhibition. Why? Because the law says you can open carry while engaged in or traveling to or from fishing. But the moment Dave stepped out of the traveling to bubble and into a commercial convenience bubble, he lost his protection. The court ruled that the gas station stop wasn't a necessary part of the travel. And if you walk into a private business like a supermarket or a bank openly carrying and they ask you to leave, you must leave immediately. If you argue, you aren't just trespassing. You are armed trespassing, which is a high-level felony. Florida's ban on open carry has been around for decades, and it's been challenged in court multiple times. The most notable case is Norman v. State, a Florida Supreme Court decision from 2017. In that case, the defendant openly carried a firearm on his hip while walking down the street. He wasn't threatening anyone. He wasn't doing anything illegal other than the open carry itself. He argued that Florida's ban on open carry violated his Second Amendment rights. The court disagreed. They held that the state has a legitimate interest in regulating how firearms are carried in public, and that requiring concealed carry instead of open carry is a reasonable restriction. That ruling is still good law today, so even under the permitless carry law, open carry is off the table in most situations. So let's wrap this up. What have we learned? Number 1, permitless does not mean anyone. If you have a history of alcohol treatment, a domestic injunction, or a withheld felony, you are a prohibited person the second you pick up that gun. Number 2, the where matters more than the why. Bars, schools, government buildings, and courthouses remain strictly off limits. Even if you qualify for permitless carry, you are still breaking the law if you bring a gun into a restricted location. Number 3, if you're carrying a gun on school property, even in your car, in the parking lot, you need an actual concealed carry license. Permitless carry does not cover this. This is one of the most dangerous traps we're seeing. Number 4, if you're carrying a gun in your vehicle and you don't meet the permitless carry qualifications, the gun must be securely encased in a storage compartment, not on your body. And even if you do meet the qualifications, think very carefully about where you're going when you exit that vehicle. Number 5, open carry is still illegal in Florida except during hunting, fishing, camping, or target shooting. The permitless carry law did not legalize open carry for everyday activities. And even with the recent court rulings, we're in a transition period where enforcement is inconsistent and risky. And number 6, the permit is your insurance policy. Even though you can carry without a permit, having one gives you reciprocity in other states, clears you for school zones, and acts as protection when an officer isn't sure about the current laws. The laws in Florida are moving faster than the average person can keep up with. We're still in a transition period. The case law is still developing, and people are still getting arrested for things they didn't know were crimes. If you've been caught in one of these traps, or if you're facing a charge because you thought you were following the new rules, you need a defense that actually understands these updates. Don't let a misunderstanding of a statute ruin your clean record. Don't guess. Don't rely on what your buddy told you at the shooting range. Don't assume that because you saw something on social media, it's accurate. If you've been charged with a firearm offense, if you're not sure whether your situation is legal, or if you just want to make sure you're carrying responsibly and within the law, check the link in the description to book a consultation. Make sure to subscribe so you stay on the right side of the law as these rulings continue to roll in. We live in these gray areas so you don't have to.